All right, so let's get started. In this lecture, we begin our conversation about sexual assault or rape. You should just know that during the course of these lectures, I will alternately use those terms, sometimes sexual assault, sometimes rape. I am, in general, talking about the same overarching concept, just so you are aware. But obviously, what we're going to do is work through some of the more finer points about rape or sexual assault, draw some distinctions in the law between forcible sexual assault, non forcible sexual assault, the rape of those who may be unconscious, or rape on the basis of fraud or coercion, and then also statutory rape. So before we begin to dive into the substantive criminal law, in particular of forcible rape, which will be the primary focus of this particular lecture, I wanted to give some introductory remarks to the topic. So first, just put our conversation about rape or sexual assault in the larger context of this class. So recall, I said early on that much of what we're going to do in the course of the class is either move through the various steps of the criminal process, from criminal lawmaking all the way through sentencing and punishment, right? And in the course of that movement, we would be talking about particular serious crimes in order to concretize our discussion. Remember, I also explained that in terms of methodology, we're going to be moving through the material from the abstract to the particular, right? And so we've had discussions about actus reus, mens rea, causation where appropriate, and we then began to examine those concepts in the context of homicide. And now we're going to examine those concepts in the context of sexual assault or rape. And I understand, and you understand, there are many different crimes that we could have covered, that we could talk about in order to bring these abstract concepts of the basic elements of crimes into more light, right? But there are significant reasons why we choose to have conversations, especially about homicide and especially about sexual assault, right? One of the first reasons might be that these behaviors are two of the most seriously concerning behaviors in society, right? Homicide has a significant impact on society, even if the numbers are not as high as for other crimes, even if homicide is not the most common crime, right? And even if most people aren't directly or indirectly impacted by homicide, right? It has significant impact because we're talking about the loss of individual life, all right? And we understand that for the most part, killing another individual is both a moral wrong and a legal wrong. With respect to the law, we talk about homicide also because it is one of the most relatively unchanged areas of criminal law from the original approach under English common law, right? So the evolution of homicide from English common law to American common law to American statutory crimes has been relatively straightforward, right? It's been on a relatively straight plane. There hasn't been too much significant variation in homicide crime from its origins. And today, it is relatively uniform across jurisdictions, even though we know that there are many more new forms of homicide that have been created, right? It is fair to say that we do have or we can create a basic sense of what constitutes homicide across the nation and on the federal level, despite the fact that there might be variation. The reason we talk about sexual assault or rape for a significant amount of time, right, is because like homicide, it is significantly impactful in terms of the social ramifications, all right? But it is slightly different in terms of its social impact, right? Many people are directly or indirectly impacted by sexual assault or rape. It is hard to know the exact numbers because of significant underreporting, because of data collection problems, and data collection differences in terms of what behavior is recognized and counted and under what circumstances, right? But it's fair to say that based on the data, which I'll touch on in a moment, many people are directly or indirectly impacted by rape or by sexual assault. So for that reason, because of its large social impact, we want to spend some extended time talking about it. Another reason we want to spend some time talking about rape and sexual assault is because of its dynamic nature, right? The dynamic nature of this particular area of law. So, on the one hand, we look at homicide because it has been relatively fixed over hundreds of years, right? And we can examine the uniformity and the continuity of homicide crimes over time. In contrast, sexual assault or rape law has been for a number of decades in significant flux, right? It has evolved in many different ways across jurisdictions and over time. And so, in contrast to looking at rape, this presents an area of law that is in continual flux and continues to be in flux. And so, for that reason, it presents an interesting area of criminal law to study as well. Okay, so those are the basic reasons why we are looking at these two particular areas of crimes, and in particular, why we turn now to rape or sexual assault. So the next part of the introductory comments I want to make relate to the data, right? In your assigned reading, you were given pages 407 to 413, which provide some background data on sexual assault, right? I want to highlight a few points, right? First, that this is self-reported data from the United States Department of Justice National Crime Victim Survey, right? This includes information that was reported and not reported to law enforcement. All right, so because this is self-reported data, this is from individuals who were willing to respond to a survey about their experiences with sexual assault or rape, even if they had not reported the information to law enforcement or government authorities. Also keep in mind that the sample that forms the basis for the survey was taken from individuals who were age 12 years or older. In other words, survey responses were taken from those individuals who were 12 years or older. All right, so that's pretty young. All right, so some significant points to note. Females from 12 to 34 years of age experience significantly higher rates of sexual violence than other age or gender groups. All right, so women, females 12 to 34 years of age are most likely to experience sexual assault or violence. Women who have never been married or divorced or separated at the time of the incident have significant rates of experiencing sexual assault or sexual assault or rape. Females in poor households are more likely to be raped, and a poor household here is defined as household income less than $25,000 annually. Women who live in rural areas experience a higher rate of sexual assault and rape than women who live in urban and suburban areas. The vast majority of victims know their offender. 1/3 of individuals are assaulted by an intimate partner. 1/3 are assaulted by a friend or an acquaintance. The numbers for stranger rape are far lower, and the numbers of individuals who are raped or sexually assaulted by a family member are less than 1/3, but still fairly high. Lastly, I want to make sure that you're just aware that relatively few rapes or sexual assaults involve a weapon. So I point this out because there are many misconceptions or misunderstandings about the basic facts of rape or sexual assault. And some of these misapprehensions contribute to how we understand the doctrine of sexual assault when we believe sexual assault has occurred, and what punishment or sentences should be imposed. I also do want to point out that while this is data from the United States Department of Justice and it's a self-reported data, right, there are many other nationally recognized data collection systems, including those issued by the Centers for Disease Control, and as well by organizations that collect information regarding campus sexual assault, right? It's important to keep in mind that while each of those various data collection systems have legitimacy, right, they might produce different numbers because each collection system uses different definitions, right? And some collection data systems rely on self-reported data. Others might rely on the reports given to law enforcement. All right. One thing that it is safe to say, and that researchers do uniformly agree with, is that the numbers of incidents of sexual assault or rape are significantly underreported, right? Underreported to government officials, underreported to public health officials, underreported in surveys and studies, right? And so that, in many ways, makes it difficult to fully grapple with the range of this particular problem and the impacts. All right, so also in your reading, I asked you to skim pages 413 to 433. The first part of that material includes some social information or social perspectives on rape and sexual assault that can just contextualize the conversation we're going to have about the doctrine, right? And as well, there is a section in those pages that deal with or that reveals to you various statutory approaches to sexual assault nationwide. All right, so if you take a look at those statutes, you can see how different jurisdictions approach either similarly or dissimilarly rape and sexual assault. And as well, that section of pages includes the proposed model penal code provisions. All right, and I will come back and talk a little bit about the model penal code approach in a moment. Okay, so now you can begin to look at the slides related to our conversation today, right? And the first slide continues some of the introductory conversation about rape and sexual assault. And here, in particular, I want to lay out for you in a large sense the traditional common law approach to rape, right? And so traditionally at common law, you must understand that rape included at least three, and in many respects, four elements, right? There was a requirement that the behavior have been forcible and against the will of the victim and non-consensual. All right, so force against the will of the individual and non-consensual. As well, it's important to keep in mind that only vaginal intercourse was criminalized. Sodomy, anal sex, oral sex were separate crimes. All right, so rape only regulated forcible vaginal intercourse against the will of the victim that was non-consensual. Rape also only applied to a male perpetrator and a female victim. And lastly, one of the most significant elements to keep in mind is that the government was required to prove victim resistance. All right, so let me summarize that again. In order to prove rape under traditional common law, the government must prove that there had been vaginal intercourse between a male perpetrator and a female victim that was committed forcibly by the perpetrator against the will of the victim and without the consent of the victim, and the victim must have resisted. As well, it was also important to keep in mind that in traditional common law, there was marital immunity. So a husband could not be convicted of raping his wife. He had immunity from criminal prosecution, even if he acted forcibly, even if it was against the will of his wife, even if his wife did not consent, even if his wife resisted. Over the last several decades, legal scholars devoted much attention to rape law, as well other disciplines such as history, sociology, psychology, and gender studies focused on rape law, and as well policymakers and grassroots advocates focused on rape law. And so over the last several decades, we've begun to have much reformation or evolution in rape law. And so today, modern statutes look quite different from that traditional common law approach. So if you turn to the next slide, what we now have is a situation in which, unlike other contemporary criminal laws, there is no national consensus on rape law, on what the law should be, when it should be enforced, how it should be punished. Laws vary widely from state to state. So modern criminal statutes often criminalize other non-forcible, non-consensual sexual intercourse, prohibit all forms of sexual penetration, not simply vaginal intercourse, are gender neutral with respect to the perpetrator and the victim. So we're not limited to a male perpetrator and a female victim. You may have a female defendant and a male victim. You may have same-sex rape. Most or many criminal statutes do not require proof of resistance or provide for marital immunity. And many criminal regimes now include unconscious or drugged victims and sex by fraud. So let me just say a little bit about why there is so much variability, right? Academics and policymakers and advocates debate this issue, and a number of reasons are pointed to, and I think it's important to keep these in the back of your mind when we're looking at the varieties of approaches to rape and sexual assault. One explanation is that unlike other criminal laws, rape and sexual assault laws regulate conduct, sexual relations that in many instances most would view as a good thing, as desirable behavior for individuals and for society. All right, so one explanation is the reason we have so much variability and so much continuing evolution is that we're trying to regulate what would normally be, under certain circumstances, desirable behavior. All right, this is in contrast to other types of criminal laws, which are regulating behavior that is, by most accounts, not desirable. Another explanation for the variability is that traditional common law approaches were developed during a time when wealthy, elite, white males were the only individuals with legal ability to create and enforce the law. And now that the ability to create laws and enforce laws have been expanded to women and people of color who were previously legally disenfranchised, and as well poor white men who were marginalized socially, sometimes legally. With that expansion of the ability of and the authority of other individuals to be involved in the criminal justice process, we now see an expansion of, or a broader recognition of, sexual assault laws. Another explanation for the variability is that social practices and norms about romance and courtship and sex and gender and race often complicate drawing clear lines, right? You may hear people say that violent stranger rape cases, which are the smaller portion of cases, are the easy cases. But again, those are not the majority of cases, all right? Most cases really do see the behavior and the understanding of behavior complicated by social practices and norms. So we get, for that reason, a wide variability in how we approach sexual assault and rape law. And then finally, another reason for such variability in the criminal law is that there are regulations and sexual assault codes that have been developed in many other circumstances, in many other settings, right? So there are many workplace rules and regulations and policies governing sexual behavior within the workplace. There are also other laws which regulate sexual behavior in the workplace, right? So employment discrimination law regulates sexual behavior or sexual harassment in the workplace. In the education community, and most recently of note, in colleges and universities, Title IX right, regulates the reporting and investigating of sexual assault and rape, as well as other offenses. But what we hear a lot about is sexual assault and rape. All right. And many colleges and universities, as well as other educational institutions and settings, have adopted their own internal policies and regulations about this behavior. All right. This additional level of regulation, whether legal or quasi legal, doesn't exist for many other types of potentially offensive conduct. We don't have workplace policies and we don't have educational institution policies about homicide. We don't need them. All right. But in the sexual assault context, we do have this additional level of regulation, and those additional layers of regulation may potentially influence how we think about criminal rape law and how we enforce criminal rape law. All right. So sexual assault and rape law is an area of law in significant flux for the last several decades, and it continues to be and will continue to be in flux probably for coming decades until we potentially reach some consensus. The variance and the flux in rape and sexual assault law has created some problems, or at least created some issues that we must confront. And again, academics and policymakers and advocates and practitioners confront these. So, how do we construct or write rape law in such a way that can guide law abiding and non law abiding individuals, right? How do we define inappropriate sexual conduct or contact, right? To what extent should rape or sexual assault law be reformed to match current attitudes or future attitudes? Or should we be trying to shape attitudes and behavior? To what extent should individual backgrounds and experience and perspectives be incorporated into rape doctrine and enforcement? Do we acknowledge the historical and continuing role of sexism and racism and poverty and other biases in the formation and the continued enforcement and evolution of rape law? To what extent should sexual contact or behavior be criminalized or dealt primarily through a civil system or dealt through a non-criminal regime? All right, so these are some of the concerns that we have to deal with when we understand that there is significant variability in rape law. And if we are going to modernize rape law, how do we contend with those various problems? So, next slide, I want to take just a moment to point out the American Law Institute's Model Penal Code approach to sexual assault, right? As the slide indicates, right, it is a code that is in transition, right? In your text, some of the proposed provisions that are currently under consideration are set forth. If you look at those provisions, those stand in stark contrast to the Model Penal Code sexual assault and rape provisions that you will find in the back of your text. All right, remember, the Model Penal Code was issued in 1962 at a very different time than now. And many criticize it for being highly outmoded and archaic and out of touch with current thinking and changes in sexual assault law. And so the the ALI is undertaking an effort currently to redraft the Model Penal Code's provisions relating to sexual assault. So on your own, take some time to look at the existing provisions in the back of your text, and then look at the proposed provisions in this particular section of reading. And at the end of our conversation about rape, I will provide you a link to look at the some comments offered by academics who are currently working on that project. Okay, so with all of those introductory comments made, if you have any questions or concerns, please make sure you go onto the relevant twin discussion forum and upload them. And I'll be sure to respond, and hopefully your classmates will also engage in some dialogue. So now we begin to focus on the first major topic in this particular section, which is the topic of forcible rape. And in this particular section, we have several cases we'll look at. I'm going to actually flip the order of those cases, right? In your reading in the text, we first look at Alston and then Rusk 1 and Rusk 2. In this conversation, I actually want to flip those cases. So we're going to talk first about Rusk 1 and Rusk 2, and then we're going to talk about Alston. So the first slide here with respect to forcible rape deals with Rusk 1 and Rusk 2, and the Rusk cases deal with pre-reform traditional common law approaches to forcible rape. And as well, Rusk 1 and Rusk 2 deal with the sufficiency of the evidence as to the actus reus elements of forcible rape, that is, force, non-consent, and resistance. Unlike the Alston case, which we'll talk about in a moment, the defendant and the complaining victim in Rusk are essentially strangers. And as well, in the Rusk case, there is no evidence that there was substantial physical harm to the victim. All right, so Rusk 1 is an opinion issued by the Court of Special Appeals of Maryland in 1979. In this particular case, we learned that the defendant is charged with second-degree rape. And in Maryland, the statutory elements of second-degree rape include vaginal intercourse with another person by force or threat of force, against the will of the other person, and without the consent of the other person. All right, and these elements I'm taking from footnote 2 on page 406. All right, so 5 elements: vaginal intercourse with another person by force or threat of force, against the will of the other person, and without consent of the other person. Notice this is a statute that is quite similar to pre-reform traditional common law. It doesn't include the express element of resistance, but we're going to talk about proof of resistance in a moment. So the way I usually like to have this conversation is to try and unpack the various statutory elements and determine what the government must prove in order to satisfy the elements. All right, so if one of the first elements that we need to address is force, let's turn to that now. So with respect to the force element, according to the court's opinion, the government must prove either that the victim resisted and her resistance was overcome by force, or that the victim was prevented from resisting by threats to her safety that caused reasonable fear. All right, so again, this is a disjunctive. The evidence must warrant a conclusion either that the victim resisted and her resistance was actually overcome by defendant's use of force, or that the victim was prevented from resisting by threats to her safety that caused her to have reasonable fear. This is what we would call constructive force. So how does the government prove that the victim resisted and her resistance was overcome? The opinion tells us clearly that there must be evidence of wounds, injuries, bruises, disordered clothing. All right. The dissent references precedent, Weinigin, for how the government can sufficiently prove resistance. There must be evidence of actual physical injury to the victim. There must be evidence that she physically resisted, such as disordered clothing, disheveled appearance. So the question that then arises is, the court has interpreted the force requirement to require either proof of actual resistance that's overcome or constructive resistance or constructive force. But that is not a statutory element. It is not an element that is within the plain language or text of the statute. So how is it that the court has authority to require proof of resistance? And the authority that the court finds is that Maryland's highest appellate court, the Court of Appeals has interpreted the statute in a prior case to permit or require proof of resistance overcome, and the legislature has not changed that ruling despite its authority and opportunity to do so. So if you recall way back to our conversations about judicial crime creation, the legality principle, and statutory interpretation, this is essentially a reiteration of those principles. The legislature enacted this second-degree statutory rape law, knowing that precedent Hazel existed, and the new statutory enactments did not change the law. So Hazel, this precedent, remains good law, and Hazel permitted or required proof of resistance that was overcome. So what's the purpose of the resistance requirement? Why does Maryland or any other jurisdiction require that a victim resist? What purpose is served by that particular element being grafted onto the statutory elements? So there are a number of reasons. One is corroboration, right? The idea that we can prevent false or sham allegations, right? The evidence of resistance corroborates the victim's claim that she did not consent to the sexual behavior and that it was committed forcibly and against her will. All right, so evidence of resistance corroborates the complaining victim's claim. Another explanation for the resistance requirement is, again, hearkening back to our understanding that most times, in most instances, sexual relations are positive. They're a good thing, and parties desire to engage in that behavior, right? Or parties might have some miscommunication about their desires. And so the resistance requirement demonstrates when the parties were not both willingly engaging in the behavior. And resistance prevents any issue of miscommunication, right? If you do not want to engage in the behavior, you will resist, you will fight it off. And if your resistance is overcome or constructive force is used, then we will determine that you have been sexually assaulted and that sufficient force has been used. A third reason for requiring resistance is this Victorian view of sex that's explained in your notes after the cases, right? That there is a loss of female virtue when a rape occurs, and a woman must demonstrate that she is a worthy victim who wanted to protect her virtue, and she can do so by resisting. When she resists and her resistance is overcome, then a social harm has been committed, and the law should rectify that social harm. So resistance preserves female virtuousness and chastity and demonstrates the unwillingness to engage in the behavior and that a social harm has occurred. All right, two final reasons why jurisdictions require resistance to be proven. One is that resistance places the male perpetrator on constructive notice that the female is not consenting. And so that reduces the risk of wrongfully convicting an individual for a very serious crime. All right, so men are placed on constructive notice that a female who is resisting does not want to engage in the behavior. And so we reduce the risk of wrongful conviction. All right, we reduce the risk that a male perpetrator who either doesn't understand the lack of consent or the unwillingness, or has a culpable mindset, a non-culpable mindset, we reduce the likelihood in either of those circumstances that a male defendant, will be convicted. And then the final reason is that even if we abolish the resistance requirement, it is possible that some jurors will still expect resistance because of ingrained stereotypes about the proper behavior of women and the notion that individuals are responsible for their own fate. And so you should take fate into your hands and resist any unwanted sexual behavior. And the good woman, the virtuous woman, resists unwanted sexual behavior. So there are many reasons why under traditional common law, And even today, some jurisdictions continue to require proof of resistance. And again, what we see here in Rusk is that even if the element is not within the plain text of the language, courts may require proof of resistance in order for the government to prove the charge beyond a reasonable doubt. So while there are many reasons for the resistance requirement, there are plenty of reasons also why jurisdictions have abolished the resistance requirement, including that we shouldn't excuse conduct on the basis that a victim failed to protect him or herself. We don't expect the victim of a robbery to self-protect in order to maintain the charge, and why should we expect the same here for rape or sexual assault? Another reason is that liability for most other crimes focuses on the acts of the defendants, not the victim. So demanding that the victim engage in certain behavior in order to maintain a charge also seems asymmetrical and inequitable. Another reason to abolish the requirement is the difficulty in determining how much resistance we should require from an individual, a potential victim. A little bit of resistance or a lot of resistance? Do we require enough resistance that could actually generate more physical harm? Because to overcome that resistance, a defendant will use elevated or more serious forms of force or assault. And then a final reason for abolishing the resistance requirement is that the harm of rape is not the loss of virtue. The harm of rape is that it is a violent act that involves abuse of power and a violation of an individual's sexual autonomy. All right, so this is a transition in our society's thinking about the harm or the result of a rape, from loss of virtue to abuse of power and violation of an individual's autonomy. So some jurisdictions maintain the resistance requirement. Some jurisdictions have completely abolished the resistance requirement, and some jurisdictions have watered down the resistance requirement, so to speak. They don't require resistance to the utmost, and they do permit proof of constructive force. That is, there was sufficient force or threat of force to overcome the victim's will or desire to resist. This is the approach taken in Maryland in the Rusk case. Kind of a moderated approach between the very strong traditional common law approach of requiring resistance to the utmost and actual physical overcoming out the resistance on the part of the defendant, and the other extreme completely abolishing resistance requirements at all. So Maryland, like other jurisdictions, takes a moderated approach. So this notion of constructive force requires demonstration of reasonable fear, and so the question has to arise, well, how do we define reasonable fear? And the dissent offers some guidance here, that there must be acts and threat on the part of the defendant that are reasonably calculated to create in the mind of the victim, having regard to the circumstances in which she was placed, a real apprehension due to fear of imminent bodily harm serious enough to impair or overcome her will to resist. So acts of force or threats of force by the defendant that will, given the circumstances as the victim finds herself in, be reasonably determined to place a real, legitimate, good faith apprehension of imminent bodily harm that is serious enough to impair or overcome her will to resist. That's a lot, all right? But that's the standard. And so in light of that standard, we have to recognize that the law is expecting complainants to conform to certain objective standards, right, of what type of behavior or what type of threats reasonably cause fear. What type of behavior or what type of threats are those that constitute the potential for imminent bodily harm? And so we're back to that question that we've tackled before: what or who is the reasonable person? One approach, as we've already seen, is that the reasonable person has no particular characteristics. They are just a blank slate, neither male nor female, no particular idiosyncrasies. On the other hand, in the other extreme, courts might adopt a reasonable woman standard or a reasonable sexual assault victim standard. In Rusk, the opinion in Rusk 1 seems to suggest that the reasonable person is one who does not scare easily, does not feel vulnerable, and is not passive. This reasonable person does not cry. So the reasonable person is sort of someone who's got some willingness and ability to fight back and will not be too scared in the situation to do so. But that, in many respects, seems to be an almost subjective, non-uniform standard. How do we determine who that person is? So if you've got thoughts, please place them on the discussion forum, and let's see if we can figure out what constitutes reasonable fear and who is the reasonable person. Okay, so the other major issue that's raised by Rusk is this question of non-consent. How do we understand as a legal matter what the government must prove to prove non-consent? Generally, non-consent is understood to require proof of statements or actions by the victim, which were clearly communicated to the defendant, and which expressly and unequivocally indicated the victim's withdrawal of any prior consent and lack of consent to a particular act of intercourse. That's a lot, right? So first, statements or actions by the victim which were clearly communicated to the defendant. So what statements or action might be sufficient here to indicate non-consent? Resistance, physical resistance, resistance that's overcome, fear based upon reasonable apprehension of imminent bodily harm. All right? And those statements or actions have to be clearly communicated to the defendant. So we certainly see in Rusk that resistance can also be sufficient evidence of non-consent. Of course, it may also be possible that a victim's express words of non-consent might be enough, but they have to be clearly communicated to the defendant. All right, so that's the first requirement. Statements or actions by a victim which were clearly communicated to the defendant, and this is a conjunctive. There must be an express and unequivocal indication of the victim's withdrawal of any prior consent and lack of consent to the particular act of intercourse. All right, so to the extent that there might have been some sexual intimacy between the perpetrator and the complainant previously, there must be a withdrawal of that prior consent. And if there had been any indication of consent to the particular act or at the particular time, there must be withdrawal of that consent as well. Okay, so now that we have that basic understanding of the definitions or the interpretation of force and non-consent, and the fact that evidence of resistance must be offered to buttress those elements, buttress proof of those elements. The question is, well, how do we apply the law to the facts in Rusk? Right? In applying the facts to the law, the Intermediate Appellate Court reversed the defendant's conviction, concluding that the evidence was legally insufficient for a jury to convict. All right, that was appealed. And in Rusk 2, the Court of Appeals of Maryland, remember this is the highest court in Maryland, reversed and remanded with directions to affirm the judgment of the criminal court, the trial court. All right, the Maryland highest appellate court doesn't reject the doctrine or the law that was set out in the Intermediate Appellate Court's opinion, but it does accept the argument of the dissent in Rusk 1 that the reasonableness of the victim's apprehension of fear was a question for the jury to determine, and the jury had determined it in favor of the government and against the defendant, and hence the jury convicted the defendant. All right? So the court's opinion in Rusk 1 offers the current state or at least in the 1970s, the current state of the doctrine in Maryland, how we understood a traditional pre-reform approach to rape, and in particular, the requirements with respect to proof of force and non-consent and proof of resistance. And here, Maryland's highest appellate court defers to the jury court's finding on the facts and affirms the conviction. So we don't have here so much of the argument that the government would have offered. And so I want to ask you on your own to think about the sufficiency of evidence, right? So the government here in the Rusk case does not claim that actual force was used by the defendant and that the victim resisted. The government's theory of the case is that the victim was prevented from resisting because of reasonable fear. So, on your own, after you finish this recording, try and outline what facts you believe would support an argument that the victim was in reasonable fear, that constructive force was used, right? What facts would prove beyond a reasonable doubt the element of constructive force? And we'll work through that. So, as I've done before, let me offer a little postscript on this particular case, right? We know that these two opinions derive from the late 1970s and early 1980s. The defendant was ultimately convicted and eventually released. And in April 2006, he was arrested in Florida for trespassing. And in July 2006, he was arrested in Florida for domestic assault. Both of those charges were misdemeanors. And it seems, based on my research, that in some way or in some circumstances, he died in November 2006. Okay, next slide. And the next case for discussion deal with the Alston case. All right, so recall if Rusk essentially involved two strangers in an allegation of forcible rape, right? Alston involves two intimate partners in an allegation of forcible rape. All right, and so in this particular case, it is June, and the victim complained to police that the defendant had raped her on that particular day. According to the statute that defendant was charged with violating, the government has to prove for second-degree rape, vaginal intercourse by force and against the victim's will, meaning non-consent. All right, so again, this looks quite like the same statute at issue in the Rusk case in Maryland. All right, this is a traditional pre-reform approach. And so again, we can focus on these elements of non-consent and force. All right, so for non-consent, right, according to the court, sufficient evidence of non-consent are statements or actions by the victim which were clearly communicated to the defendant and which expressly and unequivocally indicated the victim's withdrawal of any prior consent and lack of consent to particular act of intercourse. All right, so this is quite consistent, quite uniform with what we saw in the Rusk case in Maryland. And so a few questions I think I want to probe to understand the breadth or the applicability of this element, particularly because we're dealing with two individuals who were previously intimate partners. So the first is, well, what is the last point in the course of events at which a victim can withdraw consent, right? So recall, proof of non-consent requires the withdrawal of any prior consent and lack of consent to the particular act of intercourse at issue. So according to Alston, a complainant may withdraw prior consent or evidence non-consent up to the point of penetration. And once penetration occurs, vaginal penetration occurs, there can no longer be non-consent. I would note that this does seem to be still good law in North Carolina, although I know that North Carolina has been engaging in some reforms lately, so maybe they have reversed this. So non-consent can be indicated and prior consent can be withdrawn up to the last point of or up to the point of penetration or just before penetration. And if an individual has previously consented to sexual intercourse, the government can still prove non-consent, right? But there may not be just a general proof or demonstration of non-consent. The individual must withdraw prior consent and indicate lack of consent to the particular act that gives rise to the charge. All right, so it's a twofold indication of non-consent where individuals have had prior sexual intimacy. And in this particular case, the court finds a lack of consent. On your own, you can reconstruct the arguments that likely would have been presented to the court, right? Try and bullet out or craft an outline which would demonstrate non-consent in this particular case. With respect to the force element, we're also going to unpack the rules for a moment, and then I'll ask you to apply those rules to the facts of the case. All right, so we see here in the Alston case that the government must prove actual physical force or threats of serious bodily harm which reasonably induce fear. Right? This again looks quite like the standard set out in the Russ case. Here we get a little bit more explanation as well about this particular element. The fear can't be a generalized fear of the defendant, right? The fear must be linked to the particular sexual act at issue. So if there was just a general fear of the defendant because of past instances of violence or past threats of behavior, that would be insufficient. That would not demonstrate constructive force. There must be threats or use of force linked to the particular sexual act at issue. As well, prior history or use of force can't support a finding of fear. It must be the use of force or threat of force on the particular date related to the particular sexual act. And so here, the court concludes that there is insufficient evidence of force. Recall, there is sufficient evidence of non-consent, but insufficient evidence of force. So on your own, try and reconstruct those arguments, pull out some points that you would want to raise if you were the government. What arguments would you raise if you were the defense? And we can talk through this on Twen. How is it that the court concludes that there is insufficient force? What is the logic? What is the reasoning here? Okay, two final points of note. One, on the elements, keep in mind that analysis of both non-consent and the force elements focuses on the victim, not the perpetrator. So this is an oddity or an asymmetry in criminal law, right? Usually, when we're trying to analyze whether or not a defendant is guilty, we're focusing on the defendant's behavior or alleged behavior. Here, right, in this context of rape and sexual assault, we're focusing on the victim's behavior. Did the victim evidence non-consent? Did the victim resist? Was there a reasonable fear of imminent bodily injury? Also keep in mind, in particular with respect to the force element, that the victim has to conform to certain objective standards about whether or not she was placed in fear, whether or not her fear was appropriate, right? She also has to, in some respects, objectively satisfy some standard of physical resistance. All right, so again, the question is, who is this reasonable person? And who is the reasonable person in this particular context? Right? If under traditional common law approaches, you only had male perpetrators and female victims, is the reasonable person a reasonable female or a reasonable sexual assault victim? The last point to be aware of with respect to this conversation is that Alston is no longer in good legal standing. In a subsequent decision, the court described the case as unique and peculiar and limited the holding to the facts of the case, right? And again, keep in mind that the court in Alston concluded that there was insufficient evidence of force. I'm not sure that I agree that the particular facts of the case were unique and peculiar, right? We certainly know that there are plenty of instances in which intimate partners raise concerns and complaints about sexual assault and sexual violence. And we know that there are plenty of instances in which intimate partners might have consented to sexual behavior on one particular occasion, but might not be willing to consent to sexual behavior on another occasion. But we will take that holding subsequently that Alston is limited in its applicability. All right, so that's the end of my lecture on forcible rape or forcible sexual assault. And so I need for you to do two other things for me. The first is in the PowerPoint, there is a problem that you can address on your own time, which raises the question of whether or not forcible sexual assault has been committed when two individuals who have been dating on and off for a year go out to dinner in a nightclub, and there are some questions of intoxication, right? And little physical resistance, minor vaginal injuries, right? Has a rape occurred according to the law as we see it under the traditional common law approach in Rusk and in Alston? All right, so on your own, I guess I could say it as well, or with a partner or partners, think about this. Post some of your comments and thoughts on Twin, and at some point I'll give my comments and thoughts too. The other task for you with respect to this question of forcible rape is to take a look on Twin in the course materials section, and I have added a link to a video and a news article written or published earlier this year by The Guardian online, and you should watch the video and read the article. This is news reporting pertaining to the Harvey Weinstein case, right? If you recall, I hope you all do recall, Harvey Weinstein is the most recent high-profile individual to be charged with and convicted of forcible rape. His case presents a lot of complex issues to think about, right? But it is a forcible rape case, and one we can take a look at and examine in the context of this particular discussion. And after you watch the video, which is about 5 minutes, and you read the news article, feel free to post comments and questions about the case on Twin, and we'll take a look at those. All right, so that concludes our discussion about forcible sex assault. I hope we continue the discussion online. And next up, we'll move to issues of coercion and acquaintance rape, what are sometimes called non-forcible sexual assault. I'm not sure I very much like that term. And we'll also take a look at mens rea. So you should read the pages in the reading assignment sheet for those particular topics for the next audio recording. And then we'll finish up with a final recording that deals with fraud and unconsciousness and statutory rape.